The title of today's event is called The Founders versus the Roberts Court: Corruption, Campaign Finance, and McCutcheon versus FEC. As the title suggests, we are here in part to discuss a Supreme Court case, McCutcheon versus FEC, and it is an important follow-up to the Supreme Court's ruling in Citizens United versus FEC. McCutcheon will be argued before the Supreme Court on October 8th, the second day of the court's new term. To frame the conversation today, let me give you a little background, starting with Citizens United. In a sharply divided 5-4 ruling 3 years ago, the Supreme Court held that corporations can spend unlimited amounts on so-called independent expenditures to elect candidates of their choice. These expenditures are called independent because the money is not given to a party or a candidate. And in theory, at least, there's supposed to be no coordination between the expenditure and the campaign being supported. The ruling by the court's conservative wing in Citizens United is based on the equivalency of three things that are not really equal. The court held that money equals speech, corporations equal people, and corruption equals nothing more than bribery. Because money equals speech, the court held, and because corporations have the same speech rights as individuals, corporate expenditures on elections are subject to what the Supreme Court calls strict scrutiny, effectively the death knell for limits on campaign expenditures. Laws limiting such speech must be narrowly tailored to address a compelling government interest. And the court held for the first time in Citizens United that when it comes to independent expenditures, the government's compelling interest was limited to combating quid pro quo bribery and nothing else. With Citizens United, the court's conservative majority returned us to the Wild West in terms of regulating independent expenditures. McCutcheon is different from Citizens United in this important respects. It involves campaign contributions to candidates and parties. Specifically, McCutcheon involves aggregate limits of such campaign contributions. So limits the total amount any individual can give to a candidate or a party. The Supreme Court has long distinguished contributions from expenditures because there's a greater risk of corruption when you're giving money directly to a candidate, and there's very little control over your money once you give the money to a candidate. It is much harder to equate money and speech in this context, and so the court has applied what it calls intermediate, not strict, scrutiny to contribution limits. And as a result, the court has generally upheld limits on contributions, at least so far. A key question in the McCutcheon case is whether the court will impose the new rules, the new limits it developed in Citizens United to laws that limit contributions. Specifically, will the court continue to assert in this context that the Congress's role is limited to combating bribery? That's a critical question that we'll be addressing today. Senator Warren has done this nation a great service by very effectively highlighting the fact that when the court's conservatives depart from the Constitution's text and history, as in Citizens United, it very often does so to favor the interests of corporate America. The statistics here, encompassed in studies by both Constitutional Accountability Center, our organization, and leading lights like Judge Richard Posner, are extraordinary. Senator Warren has correctly warned of the corporate capture of the Supreme Court, and she has spoken poignantly about the impact of the court's pro-corporate rulings on the lives of hardworking Americans. And with that, I will turn the mic over to one of the nation's fastest rising political stars, a first-rate scholar, a passionate activist, and a senator who is quickly proving herself more than able to fill the enormous void in the Senate left by the death of Edward Kennedy, who held her seat for almost 50 years. Senator Elizabeth Warren. Thank you, Senator. Thanks so much.
Thank you. Thank you. Hey, you. How are you? All right, we got to get the hug out of the way first before we can get started here. So I want to thank you very much. I want to thank the Constitutional Accountability Center for pulling this event together, for inviting me here to speak. And I also want to thank Professor Lessig for this work. I've known Larry for a number of years. He is a first-rate legal scholar who is deeply committed to ensuring that our democracy works for all Americans, not just those with money and power. This is a great event because it gives me an opportunity to talk about the impact of concentrated power on our political process, how the founders viewed these concerns, and how the Supreme Court can keep faith with those views. The founders greatly feared concentration of power, understanding how concentrated power undermines a democratic government. But here in Washington, power is not balanced. Instead, power is becoming more and more concentrated on one side. There are well-financed corporate interests lining up to protect their own privileges and to resist any change that would limit corporate excess. I saw one example of this up close and personal during the fights following the 2008 financial crisis and the attempt to get regulatory reform in place. But believe me, now that I've been around Washington, I have seen many, many more examples of this. Big corporate interests are savvy. They fight every day on Capitol Hill, and they fight every day in the agencies. They devote enormous resources to the task of bending legislation to benefit themselves. They also devote enormous resources to influencing the courts. Now, I've been speaking out about the intense fight that's going on right now over what our federal courts will look like. It's a fight over whether those courts will remain a neutral forum, faithfully interpreting the law and dispensing fair and impartial justice, or whether we'll see a corporate capture of the federal courts, with the courts turned into just one more rigged game. Right now, we're losing that fight. The most prominent example of this is in the United States Supreme Court. Three well-respected scholars, including Judge Richard Posner of the Seventh Circuit, a widely respected and very conservative Reagan appointee, recently examined almost 20,000 Supreme Court cases over the last 65 years. They used multivariate regression analyses so that they could determine how often each justice voted in favor of corporate interests during their time on the bench. Now, Judge Posner and his colleagues concluded that the 5 conservative justices currently sitting on the United States Supreme Court are among the 10 most conservative in over half a century. And Justices Alito and Roberts, number 1 and number 2. And take a look at the Chamber of Commerce. Let's take a look at their win rate. The Constitutional Accountability Center has done some amazing work here. It's shown how the Chamber has moved from a 43% win rate during the last 5 terms of the Burger Court. Think about that, 43% win rate. You ready? To a 56% win rate during the very conservative Rehnquist Court, to a 70% win rate during the Roberts Court. Now follow this pro-corporate tilt to its logical conclusion, and pretty soon the United States Supreme Court will become a wholly owned subsidiary of big business. The consequences of this pro-corporate shift are staggering. For example, the Lilly Ledbetter case. Supreme Court chose to protect employers over employees, ignoring the basic principle of equal pay for equal work. Supreme Court rewrote our established understanding of the standards for filing lawsuits in Iqbal and the Twombly cases, making it easier for rich corporations to beat poorer underdogs. The court looks for every opportunity to undermine class actions, which leave big corporations free just to roll over ordinary folks. Perhaps the most well-known of the court's recent pro-corporate decisions was Citizens United, which unleashed an avalanche of secret corporate money into our political system. In Citizens United, the Supreme Court famously suggested that Congress is permitted to root out corruption only in money-for-vote quid pro quo cases. In other words, the Supreme Court says that even if Congress wanted to act, it could deal with only a small piece of the overall corruption that stacks the deck in favor of big business and other special interests here in Washington. You know, it should be clear to anyone who is paying attention that money for vote exchanges are not the only threat to our political system. Most deep-pocket corporations don't need to be so crude. The power of well-funded special interests to blanket our politics with aggregate contributions tilts our democracy away from the people and toward the powerful. Congress needs power to address all of the ways in which corruption threatens the health of our political system. And that's where Professor Lessig's research comes in. Professor Lessig's research shows that this concern about widespread systematic corruption isn't just a product of our times, but it was a concern shared by the founders. When they drafted the Constitution, they weren't just protecting the system from money for votes corruption. Instead, they were even more concerned with preventing institutional corruption that makes our system more responsive to the special interests and less responsive to the people themselves. In the upcoming Supreme Court term, I know you all have been talking about this, the court will consider McCutcheon versus FEC, a case that could eliminate aggregate contribution limits by individual candidates to political committees. If the court continues in the direction of Citizens United, we may move another step closer to neutering Congress's ability to limit the influence of money in politics, and another step closer to unlimited corporate contributions given directly to candidates and political committees. We face a clear danger. Professor Lessig's research creates a glimmer of hope that the Roberts Court will keep faith with the framers. He shows a path that will give Congress the tools it needs to protect the health of our democracy and to ensure that the American people stand a fighting chance when decisions get made. So I hope, for the sake of this country, that the Supreme Court is listening. Thank you. And thank you, Larry. Thank you, dear. Thank